Estate planning attorney Jason Lindamood here, and today we're going to talk about whether a person with dementia can make and execute a last will and testament. Now, if you're like me, many of us procrastinate about getting certain things done in life, and estate planning is sometimes one of those things. Now, some folks never seem to get around to it, and sometimes when things creep up on them sooner than they realize, things like dementia, for instance, it makes executing a valid will extremely difficult, if not outright impossible. Because we must remember, a person must have capacity to create a valid will, otherwise it'll be open to being contested on the basis of either lack of capacity or even undue influence. If a person brings, let's say, grandma into the lawyer's office and guides grandma into giving certain answers when the lawyer knows full well that she isn't aware of what she's being asked to do. So that's where the undue influence would come into play. And as lawyers and practitioners, we have to be exceedingly careful as officers of the court to guard against this. So in order to achieve that, we have to be cognizant and recognize that the standard is that the person must understand the nature of what they are seeking to do, as well as the consequences of those decisions. If we're not clear on whether or not someone has the mental capacity to rationally and intellectually understand what they are asking a lawyer to draft, as well as to execute when the time comes for them to sign their documents, then when the person passes away, that estate is going to be ripe to be contested, and that's not a good thing. In a will contest proceeding is, as you can imagine, a fairly fact-intensive process where medical records may be looked at by the judge. Testimony would probably need to be heard by the notary and the witnesses who also signed the will during the signing meeting, and things of that nature. A good rule of thumb as a practitioner when it comes to protecting yourself as well as your client and as well as your client's estate is to make sure that the client understands generally what they own, that they understand generally where they want their stuff to go, as well as how they want it to be distributed to the beneficiaries later. Now, there's really no magic words that cleanly solves this problem in a cookie cutter fashion. So it'll be evaluated inevitably by a judge on a case-by-case basis. And every case is both unique and has its own set of facts. But having the mental capacity of generally knowing what they are doing when it comes to our clients is the basic standard when a loved one comes into our office and they decide to make a will and they come in to sign that will. So the overall takeaway is that it is always better to get things done sooner rather than later in order to avoid potentially huge problems down the road. Because as we know, once someone loses that window of mental clarity, it rarely ever comes back, whether it's either because of dementia or some other unexpected reason. It just doesn't really come back. So no time like the present, as they say. Anyway, that's all I have for you today. If you are someplace where you can leave a comment, hit a like button, or even share this video, that is always appreciated if you know somebody that you think might want to see it. So thank you for watching, and I'll see you again next time.